Do you have constitutional questions? Get constitutional answers. We'll be answering your constitutional questions live, so get ready to call in now. Are you a prosecutor, law enforcement officer, or local government employee? Want to make sure you are executing the laws in a constitutional manner? Are you a city council member, township board member, or state legislator? Want to ensure the laws you pass are constitutional? Perhaps you're a citizen who wants to know the proper limits on government and the protections for your God-given liberties. Regardless of your role, call me, Constitutional Attorney Catherine Henry, with your constitutional questions during our live call-in show now at the phone number listed on the screen. And remember, together we can restore freedom.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Hello, everyone. Welcome to this next episode of Restore Freedom Weekly. I'm Constitutional Attorney Catherine Henry, and it is a pleasure to have you joining me today. So while we're waiting for some other people to come in today, I want to, first of all, I don't know if you guys even really got the notifications. I'm not sure when YouTube normally sends those out, but I was celebrating my birthday last Thursday and then my husband's birthday yesterday. So, and he turned 50 yesterday. So, I mean, I know like we look like we're only in our 20s, but anyway, that's what we were doing in the last few days. So I did not get to getting this all set up and ready to go until just a little bit ago. So anyway, that might have delayed some notifications and things like that, and maybe some people will be joining us later on that normally would have already been here in the chat. So with that being said, I'm sure you guys have probably heard by now that there was catastrophic flooding in the state of Texas, and that happened in the very early morning hours, between 1 a.m. and 4 a.m. is when things were happening in the early morning hours of July 4th. And I was watching things unfold, and the last I heard is that there were 102 confirmed deaths, and there were at least there's at least a couple dozen people still missing. 10 campers from Camp Mystic, which was along the river, that was one of them flooded. One of the camp counselors there, so 11 people from that campground are still unaccounted for one way or the other, last I saw. And then there's, of course, people, it looks like a few dozen people from other communities as well that are still missing. So I'm going to try to say this without tearing up, because if you think about it, it's pretty awful. Quite a few of the ones that were reported as unfortunately passing away because of this catastrophic event are little girls. The two it's unclear to me if there were two camps or three that were cabins, I should say, 2 or 3 cabins in this campground that were essentially swept away, and where a lot of the loss of life occurred. There's one called Bubbles Inn, and there's another one, Twins, and I think it was Twins 1 and Twins 2, if I understand it correctly. And so unfortunately, those ones were the closest to the river, and those ones housed little girls 7 and 8 years old. And so the majority of the minors that have passed away throughout this weekend were 7 and 8 years old from those 2 cabins. So what I'd like to do as we get started today, before I get to the point of answering any questions about legal or constitutional issues, is take a moment to pray for these victims, their families, any survivors that might still be out there needing to be found, because rescue efforts are still underway. So with that being said, if you could please join me in a brief prayer. Dear Lord, we thank you for all that you have done for us and all that you continue to do for us. And we lift our voices now to ask that you bring home safe the remaining missing girls, as well as other individuals still missing in the state of Texas from the catastrophic flooding events that have recently happened. That you bring comfort and peace that surpasses all understanding to the families of the loved ones who have been lost, especially the families of those little girls who have been lost. And we ask that you keep the search personnel safe as they continue to try to find survivors, as well as to recover the bodies of those who are lost. And we ask all of this in Jesus' precious name. Amen. Okay, so with that being said, let's see. I guess we can have people call in with questions. So I'm going to throw the phone number on the screen if you want to call in with your legal or constitutional questions. I think there were a few people, if I remember right, that kind of jumped in with some bigger questions towards the end of our last episode in June. And I strongly encouraged you to go ahead and give us a call during today's live stream show. So that number to call in is 616-303-0093. Again, 616-303-0093. So go ahead, give us a call with your legal and constitutional questions. And in the meantime, what I want to do is encourage you guys to start really digging into some of those U.S. Supreme Court, the recent U.S. Supreme Court cases that have come out. So a lot of you probably know by now that in June, it is typical to start getting just hammered with these new Supreme Court opinions that will be coming out, because they most often do come out in June, at least in the huge batches. A lot of the oral arguments, it's on the October calendar, so the session starts in October, and then a lot of oral arguments, I think, are heard in December. But at any rate, so a lot of decisions have come out recently. There's some good ones, some great ones, some okay ones, some questionable ones, but a lot of interesting things going on. And if you just stop and read the headlines where, you see, oh, the Supreme Court stopped, the Trump administration from doing this, or the Supreme Court has allowed, the Trump administration to do this. Sometimes even in the best of media outlets, and the one that I rely on the most is the Epoch Times, and I'll tell you why in just a minute if you haven't heard about them. But even that media outlet will sometimes be a little misleading, and definitely not near as misleading as a lot of the mainstream media tends to be on a pretty regular basis. But nonetheless, sometimes there's things in there that they don't quite... maybe it's just the headline that's misleading. Maybe it's the first few paragraphs. Maybe there's something altogether that they have just missed. So I would strongly encourage you to read the court documents yourself. Now, yeah, a lot of these opinions can be like upwards of 70, 80 pages. That is a lot to read. I get it. I understand. There's a lot in there. It could be a lot to digest mentally and be able to go through all that. So I would strongly suggest that you at least go to the U.S. Supreme Court website and read the syllabus of each case that has come down, because the syllabus is essentially the court's own summary of what the entire opinion is about. And then within that summary, they give you typically page numbers for the parts that they're referencing. So if they summarize something by saying, the Second Amendment is, has strong roots in our country's history, they might just say that statement and then say pages 2 through 11. And basically that's telling you they're summarizing pages 2 through 11 of the opinion, where they're talking about the history of the Second Amendment in the United States, and the protection of ownership of gun rights and things like that. So anyway, the syllabus is a great thing to check out, because even though it's not, I don't remember exactly who writes it, to be honest with you. I know I should know that, but it's not the justices themselves that write it. It's court staff that write it. It is still as official as it gets to having a summary and being able to grasp the main concepts that are within that court opinion. So if you haven't seen any of those before, go ahead and take a look at that. And there's something that you can also sign up for, an email digest put out by the Cornell Legal Information Institute. I think it's LII. So Cornell University's Legal Information Institute. And there is, I don't remember exactly how to sign up. I signed up many years ago. But if you sign up for that, you'll be able to get the, not so much the opinions directly emailed to you, but you'll get, within the body of the email will be the syllabus for each and every one of that day's opinions that have been released. And it'll give you, the procedural background. It'll give you the parties to the case. Like I said, that summary of what the justices have said. And then it'll tell you what the main holding in the case is and which justices participated in that particular decision versus which ones wrote a dissenting opinion or a concurring opinion, etc. And so it's a great place to try to keep up to date, especially since it comes to you. It's an email. You could choose to delete it if you want. You can choose to snooze it in your inbox till you're ready to read it. But it is a much more condensed version of being able to read those Supreme Court opinions as they come out. And why am I encouraging you to do this? Because we have got to stop relying on other people to give us the information that we need. We have got to stop relying on other people to protect our rights. And do our rights come from the government? Absolutely not. Do they come from the United States Supreme Court? Absolutely not. But in order to live in this society and successfully defend your rights, you have to know how to play their game. And their game, unfortunately, has been for quite a long time that there is an overemphasis on U.S. Supreme Court decisions, even though obviously the court gets it wrong many times, and history has proven that, such as Separate but Equal is a great example of a court case that they, decided wrongly and then corrected course later on. But nonetheless, that's where we stand with things. So although I don't want you to go around touting Supreme Court, language as the law of the land, that really frustrates me when freedom fighters are supposedly freedom fighters are running around saying, oh, well, the U.S. Supreme Court said this, or even worse, the 11th Circuit Court of Appeals said this. I don't really care what the court said. Let's start with what the Constitution says. First, you go to the Constitution. Then you go to constitutionally enacted statutes. Last, should always be last, you go to what the Supreme Court or your state Supreme Court has said on a particular issue. But it is something to keep in mind that it's important to know, just like with their court rules, right? I actually think it's a travesty that we have court rules, and it's probably a discussion for another time in another place. But I think it's one of those things that can actually serve as an impediment or a barrier for people to properly access the court system. It is a series of rules and regulations that oftentimes are overly complex, don't quite make sense to the average person, and really can prohibit people from receiving justice for technicality. And And it's not the way our system is designed to be. So anyway, even though I don't believe that there should be court rules, there are court rules. And I was, all through school, I was a rule follower. Let me tell you, I never wanted to be in trouble, never wanted to ever end up in detention, never had a suspension. I did have a racist assistant principal try to assign me suspension once, until we got to the bottom of what actually happened. But anyway, yes, if you are new to this channel and new to me, we talk about a lot of things, and I will definitely not be afraid to be the first one to say in a particular group that reverse racism, if you want to call it that. But racism occurs where even someone who looks like me, a white female, can definitely be discriminated against, especially when you're going to high school in St. Paul, Minnesota, inner city St. Paul, Minnesota, and you are the minority. That definitely increases the chance of having racism occur, regardless of what you look like. If you look different than the vast majority of those people around you, the odds are greater that people will not understand you and discriminate against you. And it's quite unfortunate, but that is human nature in many respects. So regardless, I was always a rule follower. And so I meticulously follow rules, and I will read them and reread them. And I try to be very thorough about making sure I'm up to date, because just when you think you have the rules all printed out, highlighted, indexed, and tabbed, they'll change them. And, you'll have to print out another 300 pages for that particular set of rules. And there's typically, around, I'll just say 9 or 10 chapters or books, if you want to call them, of court rules for each particular state. So you often have like a probate court set of rules, or family matters. You have civil cases, criminal cases, you have appeals. Gosh, I can't think of what some of the other chapters are, and I'm mixing up between Michigan and Florida right now. But so, for example, I want to say it's chapter 7 in the Michigan court rules, that is the appellate court rules, and that would be chapter 9 in the Florida court rules. Civil, I think, is chapter 1 in Florida, and chapter 2, or chapter 1 in Michigan and chapter 2 in Florida. You have the general rules of practice, and that's chapter 2 in Florida. Anyway, I don't know. I can't keep them all straight anymore. I don't have them all memorized. Sometimes there's special traffic court rules, or misdemeanor or low crimes rules versus felonies and high misdemeanors, things like that. So anyway, it's just one of those things that I strongly would advocate for eliminating things like court rules, because they are an impediment to free access to the justice system. However, since they are there, we must learn to play their game, and we must become educated on all those aspects. So I really am questioning whether we have, if there's something wrong going on technology-wise or what, because we have very limited comments in the YouTube chat as of now. Just some hellos, no chit-chat back and forth, no questions. So I don't know if something is frozen on my end. Let me see here. I'm going to check. Okay. Yeah, I'm not seeing much of anything there. So maybe it'll be an extremely short show today, which I'm not going to be objecting to, because sometimes we get into the 2-hour time range, and I get pretty hungry by the time we're done there. But so that is something I want you to do, is take a look at those recent Supreme Court cases. At the very least, look at the syllabus for each of those cases, and read those for yourselves. Don't trust those, media outlets. Don't even trust, your friends or family, or I don't know, if you listen to somebody. I mean, I know Dan Bongino doesn't do his show on a regular basis anymore, but him as example, or Tucker Carlson, or whomever. I mean, I'm not big into podcasts and that kind of thing, so I don't know who's big anymore. in the constitutional conservative scene. But at any rate, no matter who you listen to, I still wouldn't trust whoever it is completely, because you need to read those things. You need to know what the law says. You need to know what the court thinks the law says. And you certainly need to know what the Constitution says. So with that being said, I did want to take a moment until we get any questions, if we even get any today, to mention about the Epoch Times, because a lot of people wonder what is a good source to get information. And I'm going to go ahead and type this. Oops. Okay. So I didn't have a link or anything because I'd be trying to do too many things at once and thinking about something else while typing. But the Epoch Times is something that I think would be worthy of you checking out if you haven't already checked them out. So years ago, when I first signed up, I think it was like a Christmas present or something, I got Mike, my husband, a like an annual newspaper subscription. And then as time went on, he started to read it at first, and then I would say, well, hey, make sure to leave those newspapers behind at work in case somebody else wants to read them. And that was great and fine and everything, but he didn't often have the time to go ahead and read it. So we ended up going for a digital subscription. And I don't know if we're grandfathered into any sort of price because it has been several years since we first signed up, or if this is their standard price. But for $4.99 a month, we get their online subscription. And, we have the app, and we can go in and read all the articles. They have, I'm assuming, a pretty common feature that other entities have these days, but where you can press the button on the vast majority of the articles they have in there. You could press a button and it'll read it to you. So if you don't have time to actually sit down and read it, but you're folding laundry, or you're doing this or that, or working on something else, making dinner, you can have the audio play it to you, and and hear what the article is talking about. One of the things I love about the Epoch Times is that when they talk about things, by and large, they have within their article, they'll, let's say they're talking about a Supreme Court case. They'll talk about the Supreme Court case, and then they will reference that opinion, and then the word opinion is going to have a hyperlink, and that hyperlink is literally going to take you to this U.S. Supreme Court's website of where that opinion is located. So you can actually read those source documents yourself. Whether it's, a big case like that, whether it's at a lower court, some of these, ridiculous lawsuits that have been brought against the Trump administration, or, go back a year or two when they were just pursuing Trump on an individual basis with all these criminal and civil cases. As different motions were filed, or an order from a trial court was handed down, things like that, they will all also have those documents most of the time available by clicking a link. And whenever it's feasible, they will go ahead and just have the link available that's the public link, like the court's link. But if it's something where you would have to sign in otherwise, then they put it, somewhere where it's like on their own servers or whatever, and you can access it through them and get the PDF that way. And so I love that kind of journalism where they have the sources to back it up, and they have the sources available very easily for you as the reader to be able to access and read and look at. So you don't have to just rely on their summary within the article to be able to understand what's really going on in the world. And of course, they cover all kinds of things. It's a newspaper with traditional journalism, they call it. So of course, they talk about what's going on with political events and things like that. But they cover health issues, and they cover, leisure activities. They cover the natural disasters and all kinds of different things. So at any rate, it is a great resource that I think is worth checking out and looking into a little bit more. While we're waiting for people to call in. And I'm going to go ahead and encourage you guys, go ahead and ask questions. In fact, if you are still in the chat, I see several people were in there just saying hi and whatnot. If you're still in the chat, go ahead and say something else in the chat. And I will verbally recognize that if I can see it, because I am wondering, this is highly unusual that I don't see any activity happening in the chat, and we don't have anybody calling in. And I mean, on my end, it appears supposedly that everything is working. So that would be great confirmation to let me know we are still good to go and everything's working. But and you know what? I am going to take a second and message Lori, my counterpart in crime, to see if she's in the background there. I just wanted to encourage you guys to check out your local libraries. And that might sound pretty mundane, and goodness, why would I bother talking about something like that? But we've lived here for 4 years now in Florida. And I mean, I grew up here in the 80s and 90s. But anyway, my family and I, my husband and kids and I moved down here 4 years ago. And never bothered checking out the library a whole lot. I had physically set foot in there once, maybe twice, and you know, hadn't really heard a whole lot about it. Actually, interestingly enough, we're doing this counseling course, you know, to provide essentially lay counseling services, Christian counseling services to the community through our church. And as part of that training, there's a few books they want us to read. And one of the books was just very dry. And if you can imagine all the legal books behind me, oh, those are homeschool, those are legal books over there. Anyway, I've read thousands of pages of legal books, and those are pretty dry. So if I'm saying something's a pretty dry read and it's hard to stay awake while reading it, it's pretty dry. The topic can be interesting, but how it's presented can sometimes be a challenge. So one of the books we were reading was that. It was a great topic, but just hard to keep up with given the way that the book is written. And someone suggested to me, who's also in the training, that I check out the library, because she had found this particular book through an app called Hoopla, where it's available for free as an audiobook to check out, essentially, through our local library. And I was like, well, that sounds great. And so we went, and the whole family, we got library cards and checked it out. Emma is now, let's see, it's not even been 7 whole days since Emma's had her library card. I think we opened their library cards on the 3rd, on my birthday. We walked over there. And she has now checked out 6 books, read them, and she's, you know, so she's had 3, checked them out, read them, returned them, got 3 more, checked them out, read them. She's ready for more. She was asking this weekend to go back, and we're like, we're going to wait at least a few days because we've got a lot going on. But anyway, it's just a great opportunity for you to be able to check out different things. There's a lot of different resources, and I can't even wrap my mind around all the resources that they have available. But oftentimes your local library will have access, and sometimes only through their computers. Other times you can use an app or some other things through their website to be able to access additional resources like legal searches and things of that nature. And so I want to encourage you to go ahead and take a look. Even if you've already been a member of your local library or you've been there before and you didn't find it very helpful, take another look. Because as technology changes quite rapidly, a lot of these services are being offered to even the most of rural, you know, areas and their library systems. So it's not just the big cities that are having these opportunities and resources available for little to no cost. So, and I haven't seen, something must be wrong because I haven't seen anything from Lori. I'm not seeing anything in the chat. So I'm not even sure that we are live. Haven't even heard my husband confirm. But I will see if he can confirm right now because I know if we are live, he's watching it. So at any rate, so I won't go into a lot of other big important topics because if we are in fact having technical issues that I'm just not aware of and something is making it so you guys can't actually access this live, I don't want to waste all that time and effort into doing all that. But hopefully we do have a connection and we have people that will be asking some questions soon. Other than that, I just want to alert you guys to, I think I might have alluded to it in our last live, but I think it was May 30th, the Court of Appeals came out and issued an order to show cause in our case with the city of Ormond Beach. And so basically, the city of Ormond Beach brought a case against us in magistrate court. And the magistrate didn't follow the law, didn't follow the Constitution, didn't even follow the city's own ordinances, and ended up issuing orders that punish us unlawfully and unconstitutionally for having things on our own property that don't hurt anybody else. There's no harm. Nobody even alleged there was any kind of harm to anyone. There was no finding of harm. So the only thing they're saying is that we didn't have permits to put 3 things on our property. And anyway, so then when those orders were issued, the procedure here is that you can appeal it then to the circuit court, which is normally a trial level court, but you appeal from a magistrate level to circuit court. So we did that, and we partially won the appeal. Okay, so the judge agreed that they could not come onto our property physically and tear up our property, which is what the magistrate's orders, purported to allow the city of Ormond Beach to do. Unfortunately, she also did not even address the vast majority of our legal arguments, completely ignored everything about the city's own codes and a lot of the state statute provisions that are controlling and the constitutional provisions that are controlling. And the parts that she did address, she got wrong. She, for example, cited a 11th Circuit unpublished opinion that supposedly interpreted a Florida state statute. You don't look to federal cases to interpret a state statute when there are state cases on the books, especially ones that are published. That would be non-binding precedent. It'd be persuasive at best. But it's unpublished, so they didn't anticipate anybody else using it for any purposes. And so, at any rate, there had been plenty of cases on the books that talked about the state statutes involved, and so her analysis was wrong. And actually, that case was also wrong because the case she cited, in turn, was citing to another case from Florida. And I don't want to say misquoted it, they incorrectly paraphrased what the court was saying. They totally got wrong what the court was saying. And it's just disturbing that you have one error being cited as then truth, and then truth, and then truth, and then, it's like, whoa, can we back up? That's not what was said, and that's not what the law allows. But anyway, that's where we're at. So we then, the way the system works here, at least in this kind of a case, we don't have the option of just appealing it to another court. We have to ask the Court of Appeals, which is the next highest court, for to open what's called an original proceeding. So we have to file a petition for writ of certiorari to get them to open the case. And that's what we did over a year ago, April 7th of 2024. And so the case has been pending since then, and we filed, they made us refile multiple documents and threw all kinds of requirements at us that are not in court rules, and did not make the city of Ormond Beach actually follow what is required by the court rules. Their documents just got docketed with no problem, despite being deficient. And so it got to the point where the latest version of petition that they made us file we filed it on February 14th. That's what I got to spend my Valentine's Day doing. And at that time, a weird series of events. I had my reply brief that I submitted just 2 days later because, like I said, weird circumstances. So the city's response was already filed, and their response wasn't stricken from the docket, but my initial petition was. So anyway, May 30th, the court said, show us cause why your petition should not be dismissed as untimely. And I'm like, well, it's definitely not untimely. I followed the court rules, and I totally explained the whole case. and nothing was untimely, but they didn't actually respond to that, and the city never replied or responded about any of that issue. So I filed my response on just 4 days after their order came out on June 3rd. And then a week later, on June 10th, they dismissed the case completely with one sentence with no reason given whatsoever. So where that leaves us, unfortunately, is in a position where we don't have the legal option to appeal. We can't appeal to, we can't just go up to the next court. We can't go to the Florida Supreme Court unless certain conditions are met, because unfortunately, the way things are designed here is they were so worried about conserving judicial resources instead of just getting more judicial resources that they restricted the people's access to courts. And so the Court of Appeals is deemed pretty much as the court of last resort for the vast majority of people here in the state of Florida. So the only way we have to be able to go to the Florida Supreme Court is if we can convince the Court of Appeals to write a written opinion that addresses the statutory and constitutional issues that we've raised. And if that happens, then we then can petition and ask the Supreme Court of Florida to take the case. So we have done that. We have asked them for a written opinion. We've also asked them, though, primarily to reopen the case. So I see a couple comments coming in. It's still crazy insane how there's like almost no, by now we would have had, 100 comments or more of chit chat going on between people. So anyway, I see you, Blue Line Transparency and John. So, and yes, this is the update on my case. So this is really making me wonder. Your comment was, are there any updates on my case? And for the last 5 minutes or so, I've been giving an update on the case. So it's making me think something is a huge disconnect here. I'm not sure what's happening today with the technology or what the issue is or where it is. But anyway, hopefully this message will reach somebody somewhere and it can provide some sort of insight and help in some way, shape, or form. But anyway, so to jump back into this update, we asked them to, we filed a motion for rehearing, which in the state of Florida, you don't have a motion for reconsideration, at least in the appellate court level. You have a motion for rehearing, and that's not necessarily to get a hearing, because we've actually never had an actual hearing in the Court of Appeals. Everything has just been by pleadings, by documents. So this motion for rehearing is essentially just saying to the court, listen, you misconstrued either an important element of law or of fact, and it led to an erroneous decision. And so we're asking you to reconsider the case and essentially come to a different conclusion. And in this case, we're asking them to reconsider closing the case, so therefore they would reopen it and then decide the case on the merits, because there is a lot there merit-wise that could bring us a victory, a legal victory in this case, because there is a lot that the city of Ormond Beach has done wrong legally and that the lower courts have done wrong. And it's a huge miscarriage of justice for it to be left as is. So we have those two motions pending. So basically what it looks like is, I said, hey, Court of Appeals, please reconsider your decision to dismiss our case in front of you. If you don't, and here's all the reasons why you shouldn't dismiss the case, why you should reopen it. And if you choose not to reopen it, then here's our alternate motion for a written opinion. And the court rule said there's very specific things you have to meet in order to get a written opinion. I don't know why, but anyway, just more hurdles to accessing justice, that we need to address at some point. But it is what it is. So, and we met several of those hurdles in spades. And so I asked the court, so please, if you're going to deny us reopening the case, then please explain in detail in a written opinion why you are denying reopening the case, why you have dismissed our case, so that we can then bring it to the state Supreme Court. So we're waiting to hear from that. That's the status where we're at, where we're waiting to hear from from the Florida Court of Appeals on whether they are going to grant either motion, because it would be one or the other. They wouldn't write a written opinion if they were going to simply just reopen the case. They would eventually write a written opinion on the merits of the case if they were going to reopen it, but at this time it would just be one or the other. And if they don't, our only recourse then is going to be to file a petition for writ of certiorari in the United States Supreme Court. Unfortunately, those petitions are limited to 40 pages, and there's a lot of procedural background and jurisdictional background and things like that that takes up that space of the main argument. So, and you don't get a reply brief, you just get that one initial 40-page brief, and 40 pages might sound like a lot, but when you have the local government violating your rights, violating several of your rights in a variety of ways, violating civil local code, right? The city's own code of ordinances, violating state law, violating the state constitution, violating the U.S. Constitution, and in multiple ways. And then you have to demonstrate that because there's different aspects of each of those claims. That takes a long time to demonstrate. And yeah, they teach you in law school, if they're doing a good job, they're teaching you to limit your arguments to the best ones and, put your best foot forward kind of thing and don't overwhelm the court. The problem that I have with that is if you have strong legal arguments, if you are correct on the law and you could win the case on any one of them, how do you really pick? So for example, there are legal arguments that I dropped, that I initially was raising, that I have not brought forth to the Court of Appeals. And it's frustrating because I think it paints the whole picture. It paints the picture of what all went wrong and how the city has been vindictive from the beginning on this. And I don't know why, because I don't know these people personally. So if I don't know you, what do you have against me? This is insane. But for example, they violated my Fourth Amendment rights. They came onto my property without notice, without permission, without a warrant, and they took pictures of my property. And then they tried to use those pictures against me. And the whole context of things, they didn't have right to do that. Just the same as when I had a neighbor that showed up with a stack of stalker pictures that she obtained, who knows how. She must have stood on a ladder because they were all pictures of things that were supposedly happening in my backyard, according to her. I never saw the pictures because luckily the magistrate did sustain that objection. But it's the same concept. There's a right of privacy on your own property. And, especially if it's not something you could just readily see from standing on the street or standing on the sidewalk, you can't go onto somebody's property and take a picture, take physical items. That is a seizure under the Fourth Amendment that you have the right against unless there is some sort of exigent circumstances or there's a warrant that's issued properly. And there's never been a warrant, and there's certainly no exigent circumstances because there's no freaking crime. There's no harm to anyone. No one has ever alleged a harm. So you can't have exigent circumstances. It's not like there's somebody missing or somebody murdered or anything like that. No property damage. So at any rate, that's an example of one of the legal arguments, though, that I set aside because, you have the pictures would be set aside. But because of procedural things that happened and there was so much going on, at that point, there could be ways around it. I'm just, I won't bore you with all the legal details, but there could be ways around it where we could end up at the same result, even if they get a slap on the wrist for violating my Fourth Amendment rights. It's not going to be the scenario where the whole case crumbles and the whole case gets thrown out at this point. Okay, at this point. Because it's hard to make certain arguments and then, keep all of them intact at the same time in certain situations. So at this point, there's no benefit to me raising those Fourth Amendment arguments in court because it wouldn't get their case against me thrown out. It wouldn't get their order that they obtained illegally. It wouldn't get that thrown out. So that's an example of how it's a legal argument that's kind of weak in that it's a good legal argument. I'm right on the law about it, but in the end, practically speaking, where's it going to get me if I go to court and the court agrees with me on that issue? I need to rather pare it down to the arguments that would essentially throw out their case or throw out the punishment in the end that's being doled out against us. And so that's what I did. And even then, there are so many arguments that it is virtually impossible to try to limit it to, if I had to go to the U.S. Supreme Court, 40 pages. And here's the thing too, is there are some issues that are of first impression, which means a court has not decided that particular type of legal issue before. They have not interpreted that kind of application of a state statute, for example, or state constitutional provision before. And so on a case of first impression, one example is, here's how my case is a case of first impression. Just one example. The city of Ormond Beach is saying I have to remove my parking pavers. That's what their order says. The magistrate gave them an order that says I have to remove my parking pavers, and they are going to continue to fine me into infinity until those are gone. And that is a gross overcharging. It is violating the Eighth Amendment's prohibition against excessive fines. I mean, shoot, I could murder somebody in the state of Florida and I cannot be fined more than $15,000. But the city already thinks that we owe them over $75,000 at this point. So it's insane, right? But let's look at these parking pavers. They're saying I have to take them up. However, city ordinance says that you can't park on the street. You have to have on your own property, you have to have sufficient parking for your vehicles. That sufficient parking has to be either asphalt, concrete, pavers, or bricks. Okay. When you install those, if you need a driveway extension, so we have 8-foot wide driveways that were poured in 1949. Okay. They were sufficient at the time. According to the city, in their own code, you have to have parking spaces that are at least 9 feet wide for each vehicle. Well, we own 4 vehicles. My family members own 4 vehicles at this residence. So with 4 vehicles, that's, and we have 2 driveways that are 8 feet on either side of the property. So we have 2 on one side of the property, 2 on the other. So we have to have 18 feet in width of parking material and 18 feet of width on the other. But I only have 8. They're saying I need to pull up the pavers we put down, but the pavers we put down make it so that we have 18 feet exactly on the one side and a little bit extra than 18 feet on the other side for these vehicles to be parked. So if I pull them up, and I would be left to parking on the grass, which doesn't even grow grass. It would be weeds and sand. That's all we have here, being on beachside. Then they would start citing me because I'd be in violation of the parking aspects of the code, the city's code. Because you cannot park on sand, you cannot park on grass, you cannot park on stone, you cannot park on mulch. You have to park on brick, pavers, asphalt, or concrete. And when you do make that addition to your driveways, you can't go from the driveway and put pavers towards the center of your property, according to them. We're assuming for a minute that all these rules are constitutional for the sake of this argument. You have to start from your driveway and install them going towards the side property line. That is what their code says. That is exactly what we did. And they're saying that we have to pull them up and they would never issue us a permit because they would have to be, one of them said 7 feet from the property line. The other lady said 3 feet from the property line. They both testified to different numbers at that hearing. And so regardless, we wouldn't be able to have the 18 feet the code requires for parking if we went with their made up rules on how far we can put these pavers. So according to them, we would be in violation one way or the other. It doesn't matter. We would be in violation. That's not okay. And the issue of first impression is that by removing, if we enforce that court order to remove these parking pavers, that would necessarily put us in direct violation of the ordinance. Now, what's interesting is that our city's code of ordinances says that you can make improvements and things to your property to be in a point where you are minimizing your non-compliance, but you can't increase your non-compliance with the code. So that's exactly what we did. We increased our compliance with the city code. And they're worried about the paper aspect, the paperwork, right? That they're going to deny us illegally. That's the only thing they said we did wrong. And they have all these reasons, these made up reasons why they're going to deny us this paperwork, even though we did what the substance of the law says to do, we did that. So this is an issue of first impression, because I have not been able to find any cases, at least in Florida, where they have talked about, when you are enforcing city codes like this, that, you can enforce an order where by enforcing the order, you would then force the homeowner to violate other aspects of the city code, where you would put them further in non-compliance with city code by enforcing a court order. So it's an interesting aspect that would affect all of the state of Florida. Like, this issue could happen anywhere in the state of Florida and is likely to occur with these. I mean, this is not an uncommon thing. It's just that no one's ever called them out on the way that they're cherry picking these aspects of the law. Probably because no one has been insane enough to literally read every single city code, except for me, because I wanted to know all of what was involved, right? So anyway, that is an important aspect that in theory could lead us to getting into the Florida Supreme Court, if we have to go that route. But it's one of those things that is concerning if I have to resort to going to the U.S. Supreme Court, because the U.S. Supreme Court, quite frankly, any federal court isn't going to want to touch an issue of first impression that should be rightfully handled in the state courts. And really, I don't know what the solution is when the state courts refuse to touch the issue. When they say, no, we're just not going to handle it. They have not said I'm legally wrong on that. No one has said I'm legally wrong on that at any stage along the way. They just haven't chosen to jump on in and address it. So, yeah, I haven't heard from Mike back. I haven't heard from Lori when I texted them to make sure we were good and live and everything. And we are rounding out this hour. So I hope that this discussion that we've had today, very one-sided and all, has been able to be informative, hopefully maybe encouraging, giving you some information on where things sit with us and how we're going to keep fighting the good fight. So with that being said, I guess we're going to go ahead and round out today's show. And it's a very unusual show in that we had not a single question in the chat that at least showed up on my end, and not a single question that came through on the phone lines. Hopefully 2 weeks from today will be a much different story. So that will be July 22nd at noon Eastern Standard Time. So please make sure to join us then. It's been a pleasure to have the few of you that I did see some beginning comments and hellos and things like that. It was a pleasure to see you join the chat today. We'll look forward to our discussions at a later date. I'm going to go ahead and throw those links on the screen for anyone who might want to touch base with some of those things we talked about. Specifically that second one, restorefreedomkh.com/OB case, that has the latest documents, including that motion for rehearing and motion for written opinion that I talked about. That's 3/4 of the way down probably on that screen, but everything's listed in date order. It's chronological now, and it's sorted by court. So you just go to the Court of Appeals and scroll down to the most recent date, and you'll see that. If you want to support us in any way, shape, or form, you can go to restorefreedomkh.com/support. But if you go to restorefreedomkh.com/donate, that is where you can make a one-time donation, a recurring donation, or even have the option and information needed to be able to do a donation by check or money order or something like that. And as always, all of the resources available on our website are free. So please check out restorefreedomkh.com/resources. And hopefully as the summer goes on, I will have some time and mental capacity to get even more resources and different examples of legal documents and things like that out there for you guys. And I guess with that, I will go ahead and sign off for today. Again, it's been a pleasure, and I wish you all a continuation of happy Independence Month in this great country in which we live with our fantastic constitutional Republican form of government.
Our work to restore freedom would not be possible without support from people just like you. From the various software and hardware needed to the legal research materials, every dollar you can donate helps. Make sure to like and share this video too. And remember to follow and subscribe and click that notification button. Together, we can restore freedom.